We're going to call the House Transportation Military Affairs Committee to order. Donna, if I can get roll call, please.
All right, Representative Banks.
Here.
Representative Geringer.
Here.
Representative Larson.
Can we turn your mic on? I can't hear you.
Hi, oh, I'm sorry. Representative Larson.
Here.
Representative McCann.
Absent.
Representative Nicholas.
Absent.
Representative Posey. Representative Tarver.
Here.
Representative Wiley.
Here.
And Chairman Brown.
Here.
We have 7 present, Mr.
All
Chairman.
right. Thank you, Donna. Ladies and gentlemen, we are packed full with some bills for this meeting and Thursday, us only meeting twice a week. I'm going to try to squeeze this in as fast as we can. We've got 3 fairly easy bills. It is my intent to get through those as quickly as possible and try to move into the electric vehicle bill and allow for as much public testimony as we need at this point. So what we're going to do is we're going to go ahead and start off with House Bill 25. House Bill 25 is the Vehicle Accident Reporting Amendments. And what we'll do is I'll go ahead and have whoever from Whiteout wants to come forward and is planning on answering the questions for us. I'll just kind of give a brief synopsis of the bill so everybody is understanding what we're doing with this. So this is an interim committee bill. Ladies and gentlemen, basically what happens right now is if you have a vehicle and get in an accident, the original intent behind the law that is currently written is it requires $1,000 in damage, and then you have to notify the police department and or reporting agency. This bill basically eliminates that requirement, but then goes back into statute and says as long as the vehicle is operable and can be driven away, don't necessarily need to call anybody, but if it is inoperable, then you need to contact law enforcement. That is a high level synopsis. Colonel, if you would please introduce yourself for the committee, and you got a couple of new faces here since the interim, so thanks for coming here and appreciate you answering some questions for us.
Yes, sir. Thank you, Mr. Chair. Tim Cameron, I'm the Colonel or the Administrator of the Wyoming Highway Patrol. The summation given to you by the Chair is exactly spot on. So the intention of the bill is to reduce or do away with a $1,000 threshold for a crash. As you can imagine, $1,000 now damage to a car is very little at all. And so when you look at property damage accidents, property damage only accidents, we had almost 11,000 in 2023 and almost the same identical number. We're trying to bore down in there to see how many single vehicle accidents, but if you look at law enforcement across the board in Wyoming, we spend a significant amount of time on single vehicle or vehicle accidents that are property damage only, where a vehicle could be normally and safely driven from the scene. So what we would simply do is not write the formal crash report. It would be recorded, and almost every agency that I'm aware of has a CAD system. So it would be reported or recorded in there that an officer or trooper responded to the scene and substantiate the date and time. We'd exchange information of the drivers, and that would be it. Significantly less use of law enforcement resources and time for, again, property damage only accidents. I would stand for any questions from
Committee,
the chair of the committee.
pretty simple bill, pretty simple idea here, but I want to make sure that everybody has their questions answered. Representative Larson, please.
Mr. Chairman, thank you. As I've read this a couple of times, if I could ask you to, on page 3, and I think I understand what we're trying to do there. We kind of separate out there starting on in C that we're talking about bodily injury and death, and then we talk about that we get rid of the total property damage. But then we get into this vehicle is disabled to prevent its normal safe operation. And there's at 2 places, one at the scene, which is in A, starting on line 15. And then B, I'm inclined to think that that could be after it's left the scene, but I can't read, as I read that sentence, I can't understand it.
Mr. Chair, Representative Larson. C, I think, and I think I have a different copy in front of me, just to make sure. Every police officer who investigates a motor vehicle accident shall Is that the C paragraph that you have, sir?
Do we have a, yes,
Yes.
yes.
Yeah, and then it goes to total property damage to the extent of the vehicle is so disabled as to prevent its normal and safe operation. Just the same requirements as the previous section. So this requires us to write a crash report and submit it within 10 days. If there is bodily injury or death or the vehicle can't be normally or safely driven from the scene. And that would be either on the scene, I think A talks about at the time of and at the scene of the accident, or thereafter by interviewing participants or witnesses. I think that covers the situations where sometimes crashes are reported to us with some delay. And so there's not a scene that we can go by. So what you would do is you'd have to interview, go to where the vehicles involved are and look at the damage. That would require us to write a crash.
So,
Follow-up?
Mr. Chairman, if I may, and, you know, this is an interim committee. I see that the beginning of C talks about writing the report. And I just wanted to make sure, Colonel, that I'm understanding it. And I know that it's kind of the same. But 2, if we go to Roman 2, so we're writing the report for an accident that results in bodily injury and then total property damage to the extent that it's disabled, and then we have an A and B. And so I'm trying to figure out how A and B ties to Roman 2, Mr. Chairman, a little bit. And I get A, that's right at the scene. There's a sentence there in B that says thereafter by interviewing participants or witnesses, and I don't know what that sentence means.
Colonel?
Mr. Chair, Representative Larson, I can only submit to you that it would be in a case where we don't have a scene with vehicles at the scene, or one of the vehicles is removed or not at the scene, such as a hit and run. And then we would have to, the investigation would thereby be by interviewing witnesses, drivers, occupants, and examination of that vehicle involved.
Thank you, Mr. Chairman, and I may add a little language to help me better understand that.
Certainly. Representative Geringer.
Mr. Chairman, thank you. Sir, I guess I'm a little bit confused by the language on the first page going into the second page. So what we're saying is that there's a requirement to report the accident only if the property damage is such that the vehicle is disabled. Is that correct?
Colonel?
Mr. Chair, Representative Geringer, the requirement is to notify the police, local or state, if you're involved in a collision or a crash. And that is if there's injury or death, obviously, and if the property damages to the extent, and there are exclusions there, so disabled to prevent its normal and safe operation. Many times, probably in most instances, the citizen would just simply call the police, and an officer would make that distinction. And it would be very simple. Perfect example is if a vehicle is towed from the scene, then there would be a crash report written.
Mr. Chairman.
Follow-up?
Thank you. Colonel, I guess where I'm headed with this is that if the vehicle is damaged such that there's a tremendous amount of damage, say $5,000, $10,000, and the vehicle is still drivable, there is no burden to report that, is the way I'm reading this.
Colonel?
Mr. Chair, Representative, I think the reporting requirement would be certainly to the automobiles insured. So you would notify the insurance company. I think the insurance company would want to know if it was reported to the police or not.
Right. And
Follow-up?
sorry, Mr. Chairman, thank you. And I guess that's where I'm headed to is in order to establish, say, fault in an accident, if there is no reporting requirement to law enforcement, and it gets submitted to insurance, there's the potential that there's no fault assigned in that case. and because it hasn't been reported to the police. And so it may actually hurt our drivers in that they're not able to submit a claim that is not their fault. And that's kind of the tact I'm taking here is I'm trying to understand how this works in practice so that somebody that gets creamed from behind has a tremendous amount of damage, both cars are drivable, they don't have the burden to report, so they maybe don't report. Maybe that's a problem for them because then there is no finding of fault in that case. Do you follow what I'm saying?
Colonel?
Mr. Chair, Representative, so just for informational purposes, we do not determine fault when we write a crash report.
Gotcha.
We simply relate in that crash report circumstances of the collision. Now, certainly, I can only speak for our agency, but citations may be written for anything that's determined with probable cause if there was a violation of law. That could be to either or both parties, but we don't determine fault. That typically is done when the insurance company gets the information, not just our crash report, but reviewing their member clients' information as well.
Committee, any further questions for the Colonel? Seeing none, thank you, Colonel, appreciate that. Any other state agencies
Sheriff,
on
thank you.
this particular bill? Seeing nobody rushing to the mic, I do have somebody online, it looks like, for this particular bill, Scott Zimmerman. Donna, can you let Mr. Zimmerman in, please?
I admitted Mr. Zimmerman, he'll just have to turn on his audio and video.
Mr. Zimmerman, welcome to the House Transportation Committee. If you can please turn on your camera and audio and provide your testimony, we're waiting for you.
Thank you, Mr. Chairman. Can you hear me?
We can hear you just fine, sir.
All right, I'm Scott Zimmerman, representing Rocky Mountain Farmers Union. And we are concerned with this bill taking out the property damage part of it. In many cases in rural agricultural settings, vehicles will run off a county road or a state highway and do significant damage to agricultural property or fixtures near the road and never stop or anything. Next morning you go out to turn on your center pivot irrigation system and your controller is piled up in the ditch and there's no sign. So we would very much like to see the property damage part of the bill left intact, although we could accept moving that $1,000 to a more legitimate number of, say, $2,000 or $5,000 to adjust for the time. And I'm sure this bill has been heard quite many years ago when that $1,000 was included. Thank you.
Thank you, Mr. Zimmerman. Committee, any questions for Mr. Zimmerman? Seeing none, thank you so much for your testimony. We appreciate you joining us today.
Thank you.
All right, we'll go ahead and open this up for further public testimony. Please go ahead, come on up. If there's anybody else, we'll play musical chairs. If you're here to testify, please come forward. Mr. Thompson, please.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. The large component of our membership is your county and local municipal officers, deputies, and so forth. And our general membership, I guess I would say supports this concept. And I would be happy to kind of point out a few things that aren't really explained well in the existing statute, because what the existing statute indicates is that these local law enforcement, it says police officers, how it defines it in the statute, are required to submit this written report to the state of Wyoming. And furthermore, the state of Wyoming can determine what kind of report that, either filled out on or using. Right now, it's an online electronic copy that's covered in different parts of statute. But what it doesn't indicate in there is that law enforcement can still do an investigation if this passes as written and still have a local report on the matter, still write tickets, still do everything, and also provide that information upon request to insurance companies or private individuals. All this does is talk about the state form that is required by law enforcement to fill out and submit to the state. So in my talking to agencies across the state of Wyoming, I can't think of one that would not respond to a call for a crash, you know, when requested. And then they might show up and see minor damage, have them exchange information and move on to the next one. Or they might investigate things like a DUI, driver's license issues, any number of things that could come from that law enforcement contact. And then on page 3, it does seem kind of weird that at the time and scene of the accident or thereafter is a subset of Romanet 2. This is all language pulled from the existing statute that tries to kind of clarify that. So I guess, you know, that does just try and give us a manner in which to investigate them as hit and runs or cold reports. And Mr. Chairman, I'd be happy to answer any specific questions if the committee has any.
Committee, any questions for Mr. Thompson and the chiefs of police, sheriffs? Seeing none. Thank you so much. Any further public testimony? Seeing none, we will close public testimony, bring the bill back to the dais. Committee, what's your pleasure? Moved by Wiley, seconded by Larson Lloyd. Committee, let's go ahead and work the bill quickly. Start out here on page 1. Any amendments? Moving to page 2. Moving to page 3. Representative Larson.
I have a question for you. I feel, you know, new to the committee and you've talked about this a long time, and I'm also a little embarrassed that I'm just having a hard time getting my head around a little bit of this. But on line 10, could you just answer me when it talks about total property damage and we scratch out an apparent extent of 1,000? So is the property damage in this statute, are we just referring to the vehicle, or are we referring to other property damage that might have been caused, such as the one public comment is, which, both?
Both. It is a total of property damage. So whether
you.
that is vehicle only and or, you know, crashing through a fence or whatever that might be. And I ran a bill very similar to this probably 4 or 5 years ago. Tried to take this up to $10,000 because back your truck out of the garage and strike a blinkered mirror, it's $6,500. I wouldn't know anything about that.
So, Mr. Chairman, thank you for that clarification. That helps me better understand. And so then I'd like to go down to line 18 and move an amendment. And I would, I think the intent is to say that there's an investigation of a vehicle that may be disabled but has been removed from the scene. I think that's what we're trying to say there. And so here's some language, and I'm open to suggestions, and maybe I'll follow your lead. Maybe it is clear, but I would say, as a result of the accident, becomes disabled after being removed from the scene, which shall be determined by the investigating officer by interviewing the participants or witnesses.
So we have a conceptual amendment. Do I have a second?
Second.
Seconded by Geringer.
So a follow-up question.
Certainly.
Am I in the ballpark there of what that sentence is trying to do?
I think so. And as you're going through that, I'm struggling to put those two together. If you look at the language that is up in Romanet 2, we take basically the same exact language that's in subparagraph B, and we place that up into Romanet 2. So the stricken language on lines 18 through 21 is just reinserted up on lines 10 through 13. It may be worthy of, we can do one of two things at this point. I understand where you're trying to go with this. I'd be willing to work with you, maybe go in and talk with an attorney to see if we need to strike that and fix the language prior to committee of the whole. If we want to pass this, I can work with Donna. We can certainly try to wordsmith this with the attorneys once we come out of committee. Your choice.
Mr. Chairman, I'm open to, but as I read that sentence on 18 and 19, I can't tell you what that
What it
sentence
means.
says. And I think people reading the statute should be able to get that. Now, if the stricken language had remained in place, that makes sense. But I don't follow that. And so I'm happy to work with the committee of a whole amendment or however you'd like to do it.
The other thing we could do is, we could certainly just do exactly what you said, just remove the stricken language on lines 19 through 21 as an amendment and allow that to stay in the amendment, or stay in the bill. It's duplicative of what we see up in lines 3 through 6, where there's a, shall forward a written report. It's the exact same language put up in lines 3 through 6.
Mr. Chairman?
Mhm.
So I would, in my feeble mind, it says this vehicle is so disabled as to prevent its normal and safe operation either at the time or thereafter by interviewing participants. Is that who disabled it? Is the interviewing participants and witnesses? Who disabled it? Right? I mean,
We have some very, very unique language here. There's no doubt about that, Representative Larson.
and I think just getting rid of the stricken language, it doesn't help it because that's already up there. But, Mr. Chairman, I'm happy to work with you. I think that it does need a little work.
Representative Tarver, Vice Chairman?
Mr. Chairman, what's wrong with just raising it to 10,000 and we don't have to do all this work on this bill? Am I missing something here?
Mr. Vice Chairman, the discussion through the committee and through the interim really did fall down on, number one, we're not appraisers as the layman, right? Going out there trying to determine what $10,000 may or may not be being in compliance with the law if something looked like it was 9,500 versus 10,500. And that was also the same feedback I got about 4 years ago when we brought this forward. So the committee felt like bringing this forward, as well as the Colonel's testimony, as well as WASCOP coming forward with a mechanism to where the information provided to the responding officer, if there needs to be an investigation, can be done. However, if the vehicle is still operable, can be driven from the scene, they can call a little bit later. It doesn't have to be done at the same, exact moment that the accident occurs or the crash occurs. So there is a motion on the table.
I have a question.
On the motion? Or is it on the bill?
No, on the bill. Go ahead on the motion.
Okay, so committee,
I withdraw my motion.
okay, motion has been withdrawn. Representative Larson, I will work with you. We'll figure out a way to bring this forward if the bill passes. Representative Nicholas.
So I have a question on the normal and safe operations of the vehicle.
Okay. Can you pull the mic a little closer so people online
Yeah.
can hear you, please?
So my question is, what does that mean? Normal operation, does that mean, if the taillight's out, I would say that that's not a safe operation and/or not a normal operation, right? But it could be under $1,000 damage. And then if you have a cracked windshield, then that's a judgment call depending on where it's cracked, right? And so to me, it's a pretty ambiguous description that is based on the subjectivity of the investigating officer, I presume. That's my question. And did you guys talk about that when you put this together?
I don't remember that specifically. Colonel, could I have you join us back up here?
Mr. Chairman, doesn't that depend on who owns the car? Might be normal Lloyd.
You should see my old truck. It goes like this down the highway.
Colonel, he does bring a valid point here and a question/concern here. When we utilize the term normal and safe operation, what type of subjectivity does that give for determining what is safe and operational to the officer? And we may also ask WASCOP as well, but to your judgment call, what is that?
It's a really good question. I appreciate that. So normal and safe operation, we're using the existing terminology that was already in the statute. But beyond that, I would just say any reasonable and prudent officer, if they were to see a mechanical defect in a vehicle that would give us probable cause to stop the vehicle and potentially cite or warn based on obvious damage to the vehicle or headlight not working, taillight not working, or a cracked windshield. Not in every one of those cases would we cite and tell someone you cannot move the vehicle from this, you have to get it towed or arranged for towing. Most of the time, we bring that, the defect in the equipment to their attention, write them a warning or write them a citation, but allow them time to get that fixed. Normal and safe operation would be the vehicle can be safely driven from the scene. There's not extensive damage to the vehicle that would prevent the wheels from turning or the vehicle from stopping or damage to the extent that they could not see out of mirrors or so on. It is subjective, and we're depending on our officers to use good judgment in that case. But certainly what we see is, single vehicle or multiple vehicles where there's property damage, the vehicles are towed. And they obviously are not safe for, or capable of normal operations. So again, we're depending really on the judgment of the officers, but I would use that litmus test. If it's something that a trooper or officer would see, that they would stop a car, bring that to the operator's attention and either warn or cite. Typically, if it was that egregious, the equipment, we wouldn't let them drive from the scene. And I think we'd apply the same threshold to crashes.
And I think I do remember us briefly talking about this, but we had the discussion about, somebody with a caved-in door, certainly going to be well over $1,000 worth of damage, if they strike a parking pole or something along those lines, but the vehicle is still fully operational. We don't necessarily need them to have to call up the responding officers and do all that, so. Follow up, and then Representative Geringer.
Question is, it says normal and safe, so it's conjunctive, meaning it has to be both. But my real question is, do you really need normal?
So
What you want is a safe operation.
I would tend to say that's probably truthful to an extent. However, we are reutilizing, as the Colonel said, if you look up in lines.
Existing statute.
Exactly. So the statutory language that was previously written was just utilized back down here. More than willing to entertain a motion if you'd like, but yeah, we're just using current statutory reference.
And then there's a separate question. I'm just curious about,
Sure, we can go ahead and go with another question there, Representative Nicholas.
so when you say excluding bicycles, I take that's existing language as well. Some bicycles now are worth $20,000. The average typical good bike is worth over $5,000. So I'm just wondering, because that means you don't have to report it if it's a bicycle. And so I'm just kind of interested in if you addressed that or talked about that.
I would tend to say, as a cyclist myself, the more important portion on the bicycling or the cycling portion of that actually goes up into line 15 where injury. It's highly unlikely that if I am involved in a vehicle accident on a cycle that I'm not going to have some level of injury and I'm not going to be having an officer respond. To your point, again, I'll entertain a motion if necessary. So, Representative Geringer.
Mr. Chairman, another question for the Colonel. Is there a penalty right now for, and I tried to look, I didn't find anything. Is there a penalty for not reporting at this point?
Colonel?
Mr. Chair, Representative Geringer, I believe there is under statute, in the current statute.
Okay. So, and then to follow up with Mr. Chairman.
Please.
Just pointing out here too, that this line that we're talking about, the normal and safe operation, has to do with just the reporting. It doesn't have to do with the operation. It's just the reporting where this kicks in.
That's correct.
Mr. Chair, Representative Geringer, that's correct.
Okay. Committee, any further questions for the Colonel before we continue working this bill? Thank you, Colonel. Appreciate you coming back up.
Thank you, Mr. Chair.
All right, committee, we're on to page 3 here. Is there any motions to amend on page 3? Seeing none, moving to page 4. The effective date is the only thing we have left. Seeing nothing. Question being called. Donna, would you please call roll on House Bill 25?
All right, roll call vote on House Bill 25. Representative Banks?
Aye.
Representative Geringer?
Aye.
Representative Larson? Aye. Representative McCann? Aye. Representative Nicholas? Aye. Representative Posey?
Aye.
Representative Tarver?
Aye.
Representative Wiley? Aye. And Chairman Brown?
Aye.
We have 9 aye, Mr. Chairman.
Thank you. Committee, do I have 2 volunteers for this one? Co-manage on the floor? All right. We have Representative Wiley's already taken a bullet for us, as well as Geringer, so we're going to throw Representative Larson and Banks on this one too. Thank you so much. We will have you guys co-manage this one on the floor for me. Thank you. Let's go ahead and roll into House Bill 28, Commercial Driver's License Revisions. Misty, if you'd like to join us up here, please. And then I, again, will give a brief synopsis of this. Ladies and gentlemen, so this, the language that I have here says this bill would revise the commercial driver's license statutes, would amend the definition of serious traffic violation to include improper or erratic lane change violations and using violations for texting or using a cell phone while driving a commercial motor vehicle. Bill would authorize YDOT to waive and acknowledge test or skills test or both for CDL applicants who meet specific requirements. And it would allow expunged records of driver's licenses, suspensions for minors to be considered for CDL disqualifications. The bill would disqualify a person from driving a commercial motor vehicle for at least 1 year if convicted of driving under the influence where the person is under the age of 21 and the person holds a valid CDL or commercial learner's permit. The bill would require CDL holders who are suspected of fraudulently obtaining a CDL to be disqualified from a commercial motor vehicle for a period of 1 year. That is a high-level synopsis of this bill. Misty, would you like to provide anything additional?
Chairman Brown, members of the committee, my name is Misty Zimmerman. I am the program manager for Wyoming Driver Services here at YDOT. I thank you for that, the information that's passed along. There seems to be a lot of content in this bill. As we walk through our modernization project, which we're in the process of modernizing our driver's license system, both this bill and House Bill 30 have been brought to the committee during the interim to address some of the inconsistencies that we found, as well as clean up some of the language that exists in today's statute. One of the things that I would want to point out that we talked about briefly during the interim discussion, when you talk about serious traffic violations, so we're addressing the definition of a serious traffic violation in this bill. We are not creating existing or additional statutes or citations here. We are just defining what can be defined as a serious traffic violation. Serious traffic violations are those citations, convictions that with the accumulation of could result in the disqualification of a person's commercial driver's license. There's been some comments about what would occur if the individual had one of those citations in a non-commercial vehicle. So you have a CDL, you commit one of these serious traffic violations when you're driving your truck to and from your job. Those citations are only counted for the purposes of disqualification if they also result in another suspension or another action on your driver's license. So if you had 3 speeding serious in your non-commercial, that would be a repeat offender violation that would cause a moving violation suspension. And then and only at that point would that non-commercial violation be counted as a serious traffic violation for your commercial privileges. So that is something I definitely wanted to clear up. The other instances where we made some amendments in that serious traffic violation were adding commercial learner permit, where originally in the statute that was left out, so it just said CDL. And then also texting while driving and distracted driving while operating at CMV. The other main point that I probably want to bring up here today is the conversation regarding the 0.02 alcohol concentration for operating a non-commercial vehicle for those individuals under the age of 21. In that instance, this statute would only apply if that person held a CDL or CLP at the time of the non-commercial infraction. It would not count for your 16, 17, 18-year-olds who do not have CDLs. We hold our CDL holders to a little bit higher standard, and we feel like if you are a CDL holder and you have a violation at 0.02 or greater in your non-commercial vehicle, that it should count towards the purposes of disqualification, similar to if it would if you were over the age of 21 at 0.08. On page 5, lines 6 through 9, it talks about the expungement, and we address this with LSO specifically because our current statute states that if you have an instance of driving under the influence and you are under the age of 21, that is expunged from your driving record. And that section itself specifically talks about, for the purposes of disqualification, it would not be expunged. So if I'm 20 years old, I get a DUI in my non-commercial or commercial vehicle for that matter, that record does not go away for the purposes of disqualification. So we're continuing to hold that CDL holder to that higher standard. And then the easy one of them is the removal of or the ability for the department to waive the knowledge test. And that is specifically put into language is specifically put in as the Federal Motor Carrier Safety Administration has a program called Even Exchange. And that program specifically allows for the department to waive both knowledge and skills test, which the skills test waiver currently exists for certain classes of military operational services. So they can essentially trade their their military CDL for a federal CDL. With that, I'll stand for any questions.
Committee, before I may have Misty just breeze us through the bill here, but is there any questions on the content of the bill and/or my synopsis before we run through the bill briefly? Seeing none, Misty, would you mind walking us through your statutory changes as you went through them, but just make us walk through the bill if you could, please?
Chairman Brown, no problem. The beginning on page 1 talks about the overview that we've already discussed. On page 2, line 11, it adds the words improper or to the existing language of erratic lane change, and this is in the definition of serious traffic violations. Lines 14, 15, 18, and 19 add the words or a commercial learner permit, where we discussed that earlier. On page 2, lines 20, 21, and 23 are LSO conforming language that was added to the bill. On page 3, line 1, and also on line 6, again, we add or a commercial learner's permit to the existing definition of the serious traffic violation. Lines 10 through 14 on page 3 add the serious traffic violation for texting while operating a commercial vehicle. And lines 16 through 20 adds the use of handheld electronic devices while operating a commercial vehicle. Beginning on page 3, we talk about the examinations and visual acuity. And lines 1 and 2 on page 4 is where we talk about waiving the knowledge test or both. The existing statute says only skills test. At the bottom of that page, line 21 is just conforming language from LSO. And then as we walk into page 5, lines 6 through 9, that talks about the expungement of that record for those individuals under the age of 21 that I talked about. Beginning on page 6, this is where we create that additional disqualification for those CDL and CLP holders, and this is on lines 1 through 7. For those CDL or CLP holders who operate any type of vehicle with a alcohol concentration of 0.02 or greater if the person is under the age of 21. Line 9 just simply renumbers that section. On the bottom of page 6, the stricken language moves on to page 7. Lines 1 through 4, where we talk about the additional qualification. As you can see in the language, it just says that the department shall cancel and the person shall be required to reapply, but it doesn't give us any timeline for that reapplication period. And on line 4, we add the period of 1 year, which is consistent with federal regulation. This bill has an effectivity date of July 1, 2025. The department doesn't see any issue with that, especially where we're talking about the changes that are made in this scenario.
Committee, any questions for Mrs. Zimmerman on the bill content? Seeing none, I do have one, Misty, up on page 3, lines 10 through 20. We have the electric wireless communication device, cell phone, text, whatever that case may be. Is this mirroring federal guidelines as well? Is this something other states have? I'm trying to remember back to when we processed this bill, but I can't remember if we were mirroring existing regulation with that or not.
Chairman Brown, members of the committee, yes, this is under the definition of what is a serious traffic violation in the Federal Register or in the federal regulation.
Thank you. Okay, follow up. Representative Nicholas, hit your microphone, please. Okay, thank you.
I'm just curious about this language because now you can say, you can be driving and say, hey, Cirrus, please just send text to my wife that I'm going to be 15 minutes late. And that's all you do. There's no fingers, there's no hand movement, there's no nothing. And the idea that you can't, that is a serious violation makes no sense to me. So am I correct that that would be considered a serious violation?
Ms. Zimmerman, please.
Chairman Brown, Representative Nicholas, I would defer to my law enforcement partners in the room for whether or not it would be a violation, but this is also specifically while operating a commercial motor vehicle.
I understand that,
Follow up?
Handheld electronic devices, sorry.
but a handheld electronic device, Mr. Chairman, can be a phone that's sitting there, and it's also your roadmap, right? You've got your highway information on it, and so you're using your handheld electronic device, but you're just speaking to it. You're not touching it, you're not texting. You can say, text my wife, tell her I'll be 15 minutes late. And should that be considered? To me, we need to be specific, because if you get in a wreck, and you look at the phone, you'll see a text sent on that day, but it wasn't text because he was not paying attention to what's transpiring. It's because he just happened to be driving and swerve out the road to miss a deer. Who knows what it is, but.
Ms. Zimmerman, another way of asking that question is if we were to tighten that language up, I guess two questions with it. Can we tighten that up to where it says handheld usage of a vehicle or of a wireless communication device or handheld electronic wireless device? So I can understand where Representative Nicholas is coming from. I can push the button. I'm sure some of the new Peterbilts and Max and all those can do the exact same thing. You push a button on your steering wheel, Siri activates or Google Assistant activates, and I agree that if you send a text message, it looks like if an insurance investigator were to come in and look at that, it's going to show, hey, they were sending and receiving text messages. Is that still a violation of their CDL utilization at the federal level, regardless if it's being handheld or voice activated? So I'm trying to find out whether or not, if we tighten it up here, if we're going against the grain of what the federal regulations have.
Chairman Brown, Representative Nicholas, I would agree with you. Again, I'm not creating additional citations or statutes or anything like that. Those are already outlined in our statute, right? Alls I'm doing is creating that as to be a commercial, serious traffic violation. So a person would have to be cited under the existing Wyoming law for use of this, for then it to be considered a serious traffic violation. I think as you look at this, it's more of an enforcement thing outside of this. I'm just saying if a person were to be cited under existing Wyoming statute, that would be considered a serious traffic offense for the purposes of disqualification.
Okay. Follow up, please.
So to fix that, we would have to go into existing statutes and do it there. Is that
Ms.
fair?
Zimmerman.
Chairman Brown, Representative Nicholas, that would be my recommendation.
And then follow up on
Follow
another
up.
question. Page 2, line 11, you have an improper lane change. That means if you don't use your blinker, it's considered a serious traffic violation. Is that right?
Ms. Zimmerman.
Chairman Brown, Representative Nicholas, yes. If you look at 315209AI, which is the statute which talks about maintaining your lane of travel, that's where this section is related to. So that would be the reference section that we would look at. That would be where you would be cited under that. It's more on maintaining your lane of travel than not using your appropriate blinker, but it would be an enforcement issue as to how you were cited.
That doesn't make sense to me, Mr. Chairman, because it reads improper lane change. So erratic or moving in and out is not, to me, that's two different things.
Well, I'm glad you're not out on the road writing tickets. Ms. Zimmerman, can I have you provide the citation reference that you had on that,
Chairman Brown.
please?
It's, that reference is 315209 Romanet AI. I, Roman numeral 1.
And that, just for reference, it reads, whenever any roadway has been divided into 2 or more clearly marked lanes for traffic, the following rules, in addition to all others consistent herewith, shall apply. A vehicle shall be driven as nearly as practical entirely within a single lane and shall not be moved from the lane until the driver has first ascertained that the movement can be made with safety.
So, Mr. Chairman,
Please, yes, thank you.
Mr.
Representative Larson.
Chairman, the way I then read it is that it doesn't talk about using turn signals, it's just the way that it's done. And so, and we're basing this statute on the mechanics of how the law enforcement officer is viewing it.
Ms. Zimmerman, is that correct?
Chairman Brown, Representative Larson, that would be my opinion, yes. I would agree. This is what we've seen consistently come through.
Okay. Okay, thank you, Ms. Zimmerman. Any further questions? Okay, Representative Nicholas?
I just want to clarify what Romanet 9 does. So if you're a ranch kid and you're 19 years old and you have a beer at a branding, but you have a CDL because you're driving big trucks, and you get pulled over for having a headlight out and you blow a .02 just because he smells beer on your breath, then that's a serious violation. Is that the gist of it? You can have 0 alcohol tolerance for anybody?
Ms. Zimmerman, please.
Chairman Brown, Representative Nicholas, the law states that no one under the age of 21 can operate a motor vehicle with a alcohol concentration of more than .02. So regardless of who that is, that would be against the law. This just sets that it's a disqualification for a major offense if you are a CDL or CLP holder.
And what's the citation? on
Sure, we can have a follow-up there. That'd be great.
that? No,
Thank you.
Just would like that.
Do we have that citation, Ms. Zimmerman?
Chairman Brown, Representative Nicholas, the implied consent law for,
I know where it's at.
I'm sorry?
I just remembered what it is. It's 233 or just below it.
Okay.
Mr. Chairman?
Yes, Representative Larson, please.
It might be worthy, and my question is so in the example provided, this 19-year-old Ben of Branding had a beer and then drives, he's drinking underage anyway, correct?
Ms. Zimmerman, if you feel qualified to answer that, I will allow it. If not, you can say so.
I'll leave that with the committee.
Okay. Committee, any further questions for Ms. Zimmerman? Yes, Representative Posey.
Mr. Chairman, I was wondering, ma'am, I was wondering if, how does that work with the tribal court system? You know, somebody gets caught for a DUI or something to that matter. Do they report those instances to the state? Is that a normal procedure that's still happening, or is it happening?
Ms. Zimmerman, please.
Chairman Brown, Representative Posey, yeah, there is a requirement for all state, or for all convictions to be reported to the state. So regardless of where it occurs, municipality, tribal, circuit, all of those courts have a requirement to report that conviction to the state.
Thank you.
Thank you. Committee, anything further? All right. We will go ahead and open this up for public testimony. Actually, is there any other state agencies first? Wayne, you guys want to come up and testify on this one? All right. Seeing nobody else, committee, any public testimony on this? Seeing none, we will close public testimony, bring the bill back to the dais. Committee, what is your pleasure on House Bill? What number are we on? I don't even remember what number I'm on here. 28. Thank you. Moved by Representative Geringer. Seconded by Representative Posey. Committee, let's go ahead and walk this bill really quick. Starting out on page 1. Page 1 is mainly, almost entirely, the title of the bill. Going into page 2. Any amendments on page 2? Seeing none, moving on to page 3. Anybody want to make any amendments to page 3? Seeing none, moving on to page 4. Any changes? Seeing none. 5. And finally, 6. Nothing there. 7. Seeing none. Okay. Committee, any further discussion? Seeing none. Donna, can you please call roll call on House Bill 28?
Roll call vote on House Bill 28, commercial driver's licenses revisions. Representative Banks.
Aye.
Representative Geringer.
Aye.
Representative Larson. Representative McCann. Representative Nicholas.
No.
Representative Posey. Representative Tarver.
Aye.
Representative Wiley.
No.
Chairman Brown.
Aye.
We have 7 aye and 2 no, Mr. Chairman.
Thank you. Committee, anybody want to take this one? I'll start assigning if not. Vice Chairman, you want to help me tackle this one along with Representative McCann? Perfect. Thank you, gentlemen. Appreciate it. Committee, let's go ahead and roll right into, I believe we got number 30 up next. Is that right? House Bill 30. Misty, welcome back. And instead of me running through my deal, I'll let you, look like you were already prepared to give a brief synopsis, so I won't bore the committee with my voice anymore. We'll just roll right into you if you can give us a brief synopsis and walk us through the bill.
Thank you, Chairman Brown. Again, Misty Zimmerman, I'm the Program Manager for Driver Services. Like House Bill 28, a lot of these changes were brought about by our modernization project that we're currently running through.
Misty, could we have you get a little closer to that mic, please?
Sorry.
Thank you.
I'll slow down. This bill we talked through during the interim as well as our as well as being part of our modernization project. We look at the expiration date of our under 21-year-old licenses. We also talk through contents. We clarify some timeliness and also just amend some things regarding to replacement licenses that are identified in the statute but aren't really defined. So as we walk through the bill, again, page 1 is simply mostly information that talks about what the bill is about. On page 2, lines 17 and 18, the words "of request," the request were removed and added were receipt of certified record from the department. This was done to clarify when that 45-day timeframe started for an individual hearing. Any person that has administrative action applied to their license has the right to a hearing, and there was some confusion about when the 45-day timeframe started for OAH to set that hearing date. So this just clarifies this. On page 3.
Sure. Representative Nicholas?
Is there a requirement of how soon the highway department has to forward it to the OAH?
Ms. Zimmerman?
Chairman Brown, Representative Nicholas, there's nothing in statute that specifically states how long we have to compile that. There are several varying factors that go into that, officer signed statements, a lot of things the research that is needed. We try and do that within 10 to 15 business days, but that's not always capable or probable, but that is our process.
Yes, Representative Larson?
Just to make sure I understand the process appropriately then, so if the individual feels like they've been
Aggrieved.
aggrieved, thank you, Mr. Chairman, has been aggrieved, and he's, until this hearing takes place, he's prohibited from exercising or using his driver's license. Is that right, or am I mistaken?
Ms. Zimmerman?
Chairman Brown, Representative Larson, once a person has applied for the hearing on the action is stayed by the department. So at that point, it is stayed, the person still has full driving privileges unless it is for something else. Where that 45 days comes into is if OAH fails to set that hearing within 45 days, the person gets credit for that on their suspension.
And thank you, Mr. Chairman. I just wanted to know about the stay that corrected, because if he wasn't stayed and it took an excessive amount of time on the front end, that could be problematic, but it's not with that. Thank you.
Misty, please continue. I think we were just rolling right into page 3.
Chairman Brown, on the bottom of page 3, lines 18 and 19, this creates the fee for the replacement license that we're going to talk about a little bit further in the bill. This fee was left up to the committee and was dealt with through that means. On page 4, this deals with the issuance description and contents, and specifically page 4, lines 1 through 11, talk about a person whose license was issued outside of the graduated driver license process to a person that is under the age of 21. Today's statute says that that license must expire on the person's 21st birthday. And as we found walking through this over the years, it creates an issue. It expires exactly on the person's 21st birthday. What this would do is this would allow for any driver's license issued to a person under the age of 21 to expire on the 5th year on that person's birthday. So just like your normal license would today. It just creates that additional information. Continuing on, under 31-7-118, the existing statute talks about a replacement license. It creates Romanet A, and then also because of that we create Romanet B, but adds the A to line 15. So on lines 22, 23, and continuing on page 5 all the way through the end of that page, or line 19, it talks about the ability for an individual to apply to the apartment either by mail or in person or online with our modernization project for a duplicate license. This would be to do things like change your address. This would be, I lost my driver's license and I don't want to pay for another 5-year license. This could be get you through to the end of that original expiration date. Adding an organ donation, next of kin, those types of things that are reflected directly on your license. This creates the process as well as the requirements for a person to be eligible to create or to request that duplicate license for a lesser fee than the renewal fee would be. And then continuing on to page 6, 31-8-102, 31-8 is our identification card statute. Today, the statute reads that the identification card on the back shall read, it strikes the words, "This card is provided solely for the purpose of identification of the person described on the card," and updates that with the standardized language of "for identification purposes only." Continuing on to page 7. There's 2 here that are repealed, and I just wanted to make sure that you guys were aware of that as well. The repeal on 31-7-113A Romanet 4 is the duplicate or renewal fee. The renewal fee is taken care of already in the renewal or extension fee, and then the additional fee that we created for the replacement license would fall in there. And then 31-7-119E is repeals the statute requiring the person under the age of 21 years of age for their driver's license to expire on their 21st birthday. The final thing that I did want to discuss with this committee is this bill is currently effective on July 1, 2025. With our modernization project, we do have some concerns about that date and would entertain and ask the committee's request that the committee push that to a January 1, 2026 date. We don't believe that there's anything in this bill that if started early would have any impact on our citizens. And so we feel like we do not want to take the steps necessary to make these changes in an existing system that is going away in midsummer.
With regards to that, do you want to eliminate B and change A to January 26 on page 7?
No, Representative, we still need section 3. They still need to promulgate the rules immediately. Go through that process. It's just the actual implementation on subsection A would not be until January 1st of 2026. So 1 year from today's date, correct? And you guys feel comfortable with that? Committee, any other questions for Ms. Zimmerman? Misty, thank you for walking us through that bill.
Misty, when can we start smiling on our license plates again, or on our driver's license? That's what I want to know.
Chairman
Zimmerman,
Brown.
you don't have to answer that.
Chairman Brown, Representative Nicholas, you can today.
Oh, good.
All right. Is Seeing no further questions, thank you so much. Any other government agencies? Seeing none. Public testimony open. Do we have any public testimony on this particular bill? Seeing none, we'll close public testimony. We'll bring the bill back to the dais. Committee, what's your pleasure?
Mr. Chairman, how much time we got? We're at 1:30?
We have got 30
We
minutes.
got a little time?
Yep.
A little extra?
Not really, because we still got another bill to work.
Okay, never mind. I'll maybe do it at the end of their bill. Nothing?
Okay. Okay, committee, what's your pleasure? Moved by Nicholas, seconded by Geringer. Committee, let's roll through this bill quickly, and we will roll this through. Representative Nicholas, or I'm sorry, Larson.
Mr. Chairman, on page 7, I would change the effective date from July 1 to January 1, 2026.
Moved by Larson, seconded by Nicholas.
Question?
Question being called. All those in favor, please say aye.
Aye.
All those opposed, no. That amendment passes. Any further amendments? Question on the bill. Donna, please take roll on House Bill 30 as amended.
Representative Banks.
Aye.
Representative Geringer.
Aye.
Representative Larson.
Aye.
Representative McCann. Representative Nicholas. Representative Posey. Representative Tarver. Representative Wiley. Chairman Brown.
Aye.
We have 9 ayes, Mr. Chairman.
Thank you. Myself and Representative Nicholas will tag team this one. What's that? Oh, yes, I have. He took the last one. Yeah. All right, committee, we are going to roll right into our last committee bill. I appreciate you guys' due diligence on working through these as fast as possible today. This is our electric vehicle fee. And what we're going to do is bring up our good old tax examiners who have learned all about electricity over the interim. And I want to know first and foremost how far you've made it through that electrical handbook, Wayne. I'm disappointed you didn't bring it with you to really learn us good on that, so.
Mr. Chairman, I got tired of carrying that around. It was so big. So I changed it out for our law, which was actually
Just as
smaller
big.
than the. Good afternoon, Mr. Chairman, members of the committee. I'm Wayne Hassinger, Fuel Tax Administration at WYDOT. And with me, we've got Kimberly Peters, who's the brains of the operation. So we will be judicious if you'd like us just to start walking through.
You know
it.
what? Yeah, let's just start walking through the bill committee. At this point, what I will tell you again, this has been vetted 2 years in a row. However, if you have questions on the, I will say the merits of the bill, let's go ahead and ask as we need to. If we get into the weeds too deep, I'm going to have to stop us just because although it's fun to get into the weeds on electricity, poor Wayne starts glossing over really quick. So,
Mr. Chairman,
yes, Representative Larson.
that's shocking, but let me ask the question. So the handout we received from WYDOT on using the appropriate gasoline equivalent, right? And we use a J1772 standard, or would it be fair to say that we're going to correct that? And I'm just wanting to know if we could maybe make that assumption now as they're walking through the bill.
I think that's the correct assumption at this point. Representative Yin, Minority Floor Leader Yin, and WYDOT worked on that language, so I would say yes. That's the anticipation.
Thank you.
Wayne, I'll have you start us out. Kim, either one of you, whoever wants to start this out. Okay.
Okay, Mr. Chairman, the kind of just a high-level summary of the purpose of the bill as we see it is it actually clarifies who we should collect the tax from, the EV tax. It does move the measurement to collect the tax on kilowatts rather than the existing language of the gasoline gallon equivalent. And it essentially establishes the tax rate on electricity used in motor vehicle. So really just a walk through the bill. Lines 1 through 10 are really the bill summary on page 1. Page 2, lines 14 through 17, clarifies that the $200 decal fee is for all electric vehicles. Lines 19 through 21 on page 2 create a $100 fee for plug-in hybrid vehicles. Moving to page 3, line 6 modifies the definition of billed gallons to include kilowatt hours. Lines 10 through 11 on page 3 modifies the definition of bulk alternative fuel, which removes the gasoline gallon equivalent as a measurement. And really that's done because we want to add the measurement of kilowatt hour. Lines 16 through 18 on page 3 modifies the definition of dispenser to include alternative fuel. Moving on to page 4, lines 5 through 14 modifies the definition of hybrid electric vehicle. And lines 16 through 23 on page 4 modifies the definition of plug-in hybrid vehicle. On to page 5, lines 9 through 17 adds the definition of an all-electric vehicle. Lines 19 and 20 add the definition of charge. Lines 22 and 23 and lines 1 through 4 on page 6 add the definition of DC fast charging station. And we have suggested an amendment to that definition to refine it even more. So, Mr. Chairman, I don't know if you want us to keep going or talk about the proposed amendment at this point or wait till the end.
Let's go ahead and have you work that in, so that way we kind of understand. I mean, we got the memo, but I think it would be beneficial to go ahead and have that worked in. Representative Larson?
Mr. Chairman and Wayne, if I could come back there on 3, on page 3, line 19, where we deliver this in its existing language, where we deliver it into the fuel supply tank. And I don't know that that exists on an electric car. And just wonder if there's value, Mr. Chairman, when we consider this moving as we're working it to say the fuel supply system rather than a tank? Or am I just being nitpicky anal on
I see
this?
Kim getting ready to answer.
I think okay, Mr. Chairman, Representative Larson, this is specific to all alternative fuel, not just electricity. So you do have alternative fuel that is delivered into a supply tank of a motor vehicle?
Mr. Chairman, thank you. And so Kim, I agree, but not all alternative fuels are in, and so there's a conflict there. And what I'm trying to do is clean that up a little. They all have a fuel system.
Mr. Chairman,
Kim, yeah.
Representative Larson, agreed.
Thank you.
Yep, okay. Yes, Representative Nicholas. How about you, Mike? Thank you.
It's on.
Now it is. You have good staff over
Fast
there that's
fingers
watching
over
out for you, yeah.
Good, thank you. I'm going to back up. So I'm just a little bit confused about the hybrid electric vehicles. One says you can plug it in on a wall and one says you can't. For example, I've got a Jeep Wagoneer, Cherokee, that I can plug in. I thought that was a hybrid, but this says you're using it in 2 different ways. I just want to understand the difference between a hybrid electric vehicle versus one you can plug into to your wall. And is there a difference in between the different hybrids? That's what I don't understand.
Mr. Hassinger?
Mr. Chairman, Representative Nicholas, so here we are, fuel tax folks, right? Like diving head into this electricity thing. Our understanding is there is a difference between a plug-in hybrid, which is an electric vehicle that you can plug into a wall and charge the battery, versus a hybrid that is not a plug-in, which generates electricity.
So,
Off of
as
braking.
Yeah, just as it's driving down the road and stores that electricity, but you cannot plug it into an outlet and charge it. So our understanding, see, I look at her to make sure that is our understanding, that is the difference between the two, that there are electric vehicles that you do, hybrid electric vehicles that you do not plug in, and then there are the plug-in type that have the ability to plug it into a wall and charge the battery.
so that
Follow?
that leads to another question. So in my vehicle, if you brake, it uses that combustion to help charge, but I can also plug it into the wall. So that would be basically a plug-in hybrid,
That's correct.
right? Okay.
Yep. Okay.
So I don't have to pay the $100, right?
No, you do.
Why?
You do.
Okay.
And if you'd like, we can take that up. If you're more than happy, we can increase that price. Yeah. Wayne, if you'd like to continue on, please, I think we were just getting into page 6, line 2, where your guys' definition is being adjusted. And I think instead of having you go in deep into it, just explain the rationale. Again, we got this. I'm hoping everybody at least browsed over the understanding of what it is, but if you can just read that in, it's how you recommend it.
Sure, Mr. Chairman, as we've worked through this, we really identified it would be helpful to refine that definition more, because there is still not an absolute standard language related to EV chargers. There are AC level 1 and level 2, and then there are DC level 1 and level 2 and level 3 on the horizon. So the existing definition for that fast charging station is a little challenging, where, and we actually consulted with Representative Yen on a way to refine that. And as you see in your memo down there, it seems like cleaning it up was a better idea. And not referencing the J172, that big book you used to carry around that nobody's read, because that language could be confusing and would get updated in that standard. So it appeared that it would be better to refine it and maybe take a little language out. So as far as administering the tax, this language makes it somewhat clearer on how to do that, because the existing language doesn't speak to the level 4 that will no doubt be right around the corner for the DC charger. So as challenging as it is sometimes to update statute, seemed like the suggestion would be to make it less specific.
Are you saying it's hard to work with us, Wayne? I'm just
No,
kidding.
Mr. Chairman, no. I relish these moments in front of you.
All right, so committee, any questions on the proposed amendment as being brought forward for Wayne, or Kim for that matter? I feel bad, I keep referring to Wayne, okay, all right. We can call on you more often if you'd like, but Wayne, let's go ahead and roll through to page 7, please.
Okay, Mr. Chairman, let's see. I think still on page 6, lines 17 through 21, requires each dealer to collect the license tax imposed, and requires all fast charging stations to be metered. Then on to page 17, lines 1 through 4, requires each person who sells or offers to sell alternative fuel to conspicuously display a sign stating the price per kilowatt hour. And I think we actually have a second amendment, Mr. Chairman, related to that. And it speaks to where were we changing it to? So in that, where we say display a sign stating the price per kilowatt hour, because this deals with all alternative fuel, the other amendment that we proposed is changing that to unit of measurement instead of kilowatt hour, which would only be specific to electricity. Let's see. Moving down from that, on page 7, line 17 through 22 adds a 4 cent per kilowatt hour license tax on all electricity sold or dispensed for the purpose of propelling a motor vehicle. So that really is the amount of the tax.
Mr. Chairman,
Yes, Representative Geringer.
a question on that. It appears that the way that's worded, it could include home charging because we don't refer back to at a DC fast charging station.
Mr. Hassinger.
Mr. Chairman, Representative Geringer, I believe because we are on imposition, I'm just spitballing here as I turn the pages. The point of taxation would identify the DC fast charger, which, so in the law, in statute, that delineation between point of taxation and the imposition of how much would make it clear, maybe only to us. So that would be fair if that's not clear enough. But for us, as we use the statute, the point of taxation is very important as to the delineation between residential or even a level 2 AC level 2 charger at a hotel versus the DC fast charger.
Fair enough.
Wayne, just on that, I'm wondering if, and this is again spitballing here as well, but in 3917-305 are the exemptions to make it explicitly clear, and I can work with LSO on this. I'm wondering if we ought to list an exemption for electricity charged at one's individual residence or something along those lines, just to make it explicitly clear. I know I'm throwing this out there, something we never even really discussed, that we discussed it, but not necessarily in this context. Is that something that you think might be beneficial, just to ensure that there's no questions asked about somebody trying to do this at home?
Mr. Chairman, I think we would view that as a fair thing to do. I would note that the only exemptions in fuel tax statute are for exported fuel.
Yep.
So we do not have a number of exemptions in our statute. There are a good number of parties that come back and get a refund, but there's really nothing listed as an exemption. So doing that would be new to our statute. But I think because our intention is to be clear, this is not about residential at all. So, thoughts?
I'll take a look at that with LSO, pending our approval of this and seeing if Ms. Hanson has any ideas on that. Looks like we're back to, I just scrolled on accident. Are we on to page 8? Okay.
Page 8. Mr. Chairman, page 8, line 11 adds kilowatt hours to the reporting requirements for a supplier. Line 19 adds kilowatt hours to the reporting requirements under alternative fuels purchased from out of state under the compliance section. Page 9, lines 4, 12, and 19 adds kilowatt hours to the reporting requirements for suppliers with a retail location, distributors, and importers under the compliance section. Page 10, line 6 adds kilowatt hours to the reporting requirements for a person transporting, conveying, or bringing alternative fuel used to propel a motor vehicle into the state for sale. Lines 13 and 14 on page 10 adds kilowatt hours to the reporting requirements for a person exporting fuel from the state. Lines 23 and line 3 on page 11 adds kilowatt hours to the reporting requirements for a dealer who is not licensed as a distributor. Page 11, lines 11 through 15, adds a misdemeanor penalty to any person who does not display the price per kilowatt hour, including all applicable taxes, at locations where alternative fuel is sold. Line 17 repeals Wyoming Statute 303A II, which is an obsolete provision, which is really us just, since we're in there, that is a provision that no longer applies. Lines 19 and 20 requires YDOT to promulgate rules necessary to implement this act. And on page 12, lines 3 and 4 provide for an effective date of July 1, 2025 for the promulgation of rules necessary to carry out this act. And lines 6 and 7 provide for an effective date of January 1, 2026 to allow time for reprogramming of necessary software related for the collection of the fuel tax.
All right, Wayne, thank you. Kim, thank you as well. Committee, we've got, I'm going to do about 4 minutes worth of questions here. We are going to continue this on since Wayne relishes in coming in front of our committee. We're going to bring him back for one more day on Thursday. We'll take this up, but Representative Larson, please.
Thank you, Mr. Chairman. And if I could ask you, Wayne or Kim, to go back to page 5 and 6. I want to make sure that I've got the language, Donna, for this amendment that YDOT, so when we get ready to propose it accurately. The way I see it from the handout that we got is that on page 5, on line 23, after means, we would insert public charging station / then delete because it's /device. After device, we would delete the rest of the line 23, which was used to charge, and insert that is capable of providing. Then on page 6, if I've got this put together right, we would delete all of lines 1, 2, 3, and 4, and we would insert new language that's provided there that says direct current DC power 50 kilowatt or more directly to an electric vehicle's EV battery. Am I reading that accurately? So when we get to that point, we've got that. Thank you. Hey, and Mr. Chairman?
Representative Larson.
Thank you. One other thing as we went through this. It's really fun to have Wayne and Kim here. If you look on page 3, lines 15 through 19, that was when we talked about compressed natural gas equivalents, and they helped me put that. That was my bill.
Well, hot diggity dog. Representative Nicholas.
We're talking about exports or imports of fuel, and you're talking about the export-import of a kilowatt hour. That means, I don't quite understand that.
Wayne, I think we had this discussion briefly with Senator Colby, as a matter of fact, on whether or not we actually needed to add this, but please, I'm blanking on whether or not we actually need to, so.
Mr. Chairman, Representative, I believe the intention is just to make it consistent throughout the law that we don't believe that anybody's going to be exporting or importing electricity. Stranger things have happened, but it really is to make it consistent.
We export a lot of it.
Right, but not to put in a vehicle.
Not for export of vehicle charging, though.
Particularly, well, but it is. I mean, down the road it is. I mean, because our power People are using it in Utah, they're using it to charge vehicles, or using it in Seattle to charge?
Well, so there is some truth to that because of subsection E, where it's each licensed distributor, importer, exporter with Wyoming retail location shall report. There was discussion on this, and I do remember this, I believe this was in Laramie that we ended up having this discussion. Certainly could look at striking that conforming language. I think the intent there, as Wayne was saying, is this was a conforming amendment to bring through from Ms. Hanson to ensure that we had kilowatt hours added in there for anything that was associated with this. If you're uncomfortable with it, I certainly wouldn't mind us having that discussion Thursday when we work the bill.
Mr. Chairman.
Wayne, yes.
There is an instance right now where we have a supplier that has retail locations that does have a EV charger. It's not a DC-3 fast charger, but that could certainly be in the future. And so the idea of using the term supplier as we currently use it in the fuel business, there's application to that supplier that does have a retail outlet that does have a charging station. But that is likely few and far between for the foreseeable future that we would have a fuel supplier that opened a DC
Fast charging system.
fast charger at their location.
Representative Larson, and then we're going to close up for today and we'll come back on Thursday.
Thank you. And Wayne, on that section E, with each licensed distributor, importer or exporter, what is it that the importer is importing and the exporter is exporting? Trying to get my head around who those people are, Mr. Chairman.
Mr. Chairman, Representative Larson.
Please.
In the fuel world, they're importing or exporting, right? Gasoline or diesel or,
From out of state?
Mr. Chairman, yes,
Please.
Representative. Either importing it from out of state or exporting it.
So fair enough to their point, Mr. Chairman. I think that we might want to consider the potential that along state lines, you could have an independent power producer that then is importing or exporting from another state into the state that to be used just for electrical charging. So I'm just trying to get my head around what we were talking about.
Okay. Wayne and Kim, thank you. I do apologize. We are going to bring you guys back here Thursday just to make sure that we're good to go while we work this bill. We'll take public testimony on Thursday as well. We've got plenty of work to do with this. And then I will be posting the notice for Thursday. We'll work an additional 3 bills on top of that. But with that, committee, we're going to go ahead and adjourn and we'll see you Thursday.